So New York responded to the Supreme Court. Now GOA has responded to New York's response. So it's a response to a response. Let's go ahead and talk about it. What's up, Wolverines, and welcome back to the channel. It is me, John Crump, Gundy nominee, and check out the graphic that Hank Strange made for me. If you don't follow Mr. Strange, you really need to. So go over to hankstrange.com, give him a follow, and in the comments, write John Crump sent me. He is the OG of gun tubers, and he is the guy that actually got me to start creating YouTube videos when I was just a writer. Now I'm doing YouTube as well. So thank you, Hank Strange, for all the support in the past. Go ahead, like, comment, and subscribe. It means the world to me. And with that, let's go ahead and kick off the story. GOA has responded to the Supreme Court brief filed by the state of New York. And before I get into what GOA said, let me back up a little bit and give you a little bit of history. You can check out a bunch of other videos I have done on the subject, but it deals with the CCIA, which is known as the Concealed Carry Improvement Act. It is a law that New York passed in response to Bruin, and I'm not going to go over the law because I've done that multiple times and I'm starting to feel like a broken record. So you can go back and watch my videos or you can read the law for yourself. But it is a response to Bruin. And New York was claiming in their brief to the Supreme Court that they passed the CCIA to pit themselves in line with Bruin, which isn't the truth. In fact, Kathy Hochul, who's the governor of New York, has said in multiple interviews that she's pushing back against the Supreme Court. She called the Supreme Court decision in Bruin egregious and a bunch of other nasty things. So New York claiming that it is a response to pit themselves in line with Bruin is a flat out lie, and GOA calls them out by showing some of the quotes and some of the other stuff that Kathy Hochul has said. New York also claimed that interlocutory posture in this case would prevent it from being taken up by the Supreme Court, which GOA argues is not the case. Interlocutory posture is also known as interim appeal, and you can look more up about that, but it's just when you appeal certain aspects of the case while it is still going on. GOA is claiming that's not relevant to the court's decision for a couple different reasons. One, that it's patently unconstitutional, that the law is so unconstitutional that it is patently unconstitutional. And also that the 5 judges would agree with the district court's decision. New York tried to argue that it was unreasonable to believe that 5 justices would agree with the district court, which I patently disagree with because they passed the CCIA in response to Bruin as a repudiation of Bruin, so I'm pretty sure that the courts will find it unconstitutional. And then there's the thing where New York tried to argue that the Supreme Court would most likely not hear the case because it waits years to hear cases that have to do with other cases that they have already ruled on. And GOA argues against this in a few different reasons. They highlight Heller for one, and then they also highlight the GPS tracking case. You see, the Supreme Court issued an opinion stating that the police need a warrant to place a GPS unit on someone's car before they were doing it without a warrant. The Supreme Court ruled that that's a violation of the person's Fourth Amendment rights. Then shortly thereafter, there was another case about a drug-sniffing dog on someone's porch without a warrant. The Supreme Court applied the case with the GPS to that, and that didn't go through a bunch of different levels of the court system before it went to the Supreme Court. And so it's not uncommon for the Supreme Court to grant cases like this. Another thing is New York is claiming that the stay preserved the status quo, but the law did not go into effect until September. So the status quo is probably pre-CCIA in New York, but that is for the Supreme Court to decide. Also, GOA is claiming that New York failed to undermine their likelihood to secede. One of the things that they talked about is under New York's urging, the Second Circuit applied the wrong standard. I'm not going to get too much into standards or anything like that because it gets way down into the weeds. And I know I'm going to go into the weeds if I start talking about it. And I don't want to do that. Also, New York failed to demonstrate any errors in the district court's analysis. Basically, they just try to say, hey, give us a stay because we don't like what the district court says. And the Second Circuit said, sure, because they are anti-gun. Also, New York tried to say that the CCIA does not implicate the Second Amendment. GOA pushes hard against this because this is something that New York cannot allow. If it is found that it does deal with the Second Amendment, then they have to show how the law is in line with the original text and history of the Second Amendment, which they cannot do. So GOA is pushing them hard on this because this could unravel their whole entire stance, and I think it probably will. GOA also objected to the state trying to say that one of the plaintiffs didn't have standing because he did not have a concealed carry permit. GOA points out that he's been trying to get a concealed carry permit for about a year, but he needs to get an interview and a bunch of other crap, and he's been waiting a year to get that, and through no fault of his own and delays caused by the state, he has not been able to get that interview. They also point out that the sensitive areas in New York is too overly broad. In fact, they point out how Kathy Hochul couldn't name a specific place that someone could carry. She said probably some streets, and GOA points out how that shows that they misapplied Bruin and made most of the state a sensitive area, even though that they were supposed to use that very, very sparingly. Only certain government buildings and schools could be considered sensitive places, not just because it is a place where people gather. Times Square. Also, they attack the restricted locations in this brief, pointing out that a place becomes a restrictive location by default unless they post signs saying that you are allowed to carry guns there, and the penalties for carrying in a restricted area is the same as carrying in a sensitive area. They also attack the equity fair argument, which they call unpersuasive, because we really can't even use public interest in cases like this. So New York tried to say that a stay was necessary to prevent regulatory chaos and public confusion, which GOA wholeheartedly rejects. And they give a bunch of cases that stand on their side of the argument. So it's very interesting that New York tried to do that. And in conclusion, GOA says that the Supreme Court should vacate the stay of the Second Circuit Court because it applied the wrong standard and it was just wrong in issuing the stay. GOA then repeated their request for the Supreme Court to vacate the stay issued by the Second Circuit. I think that the Supreme Court will come back with a decision pretty quickly, whether it is to just vacate the stay, Sotomayor herself doing it, or if it goes to the full bench, which will vacate the stay. But I'm pretty sure the stay will be vacated and GOA will have a victory on the Supreme Court level of the CCIA, which will put other states like New Jersey on notice because there is a TRO hearing that happened today. All right, guys, that is it. Remember, vote for me at the Gundies. Help me win, even though I don't have a real good shot at it. There is always that outside chance. So you're telling me that there's a chance. All right, guys, remember that I love you. Stay ever vigilant. Stay ever free. Keep in the fight. I'm out of here. Wolverines, motherfucker.